Hey guys, doing another quick legal tip here from Fort Lauderdale, Florida. As you can see, that's the canal back there, and the downtown's right there. But anyway, if you get a chance to go to Fort Lauderdale, I would highly recommend it. I also highly recommend doing one of the tours in the canals at nighttime. It's so amazing. Have houses, $160 million house we saw, Dave Thomas's from Wendy's, his house, Wayne Huizenga, who used to own the Marlins and the Dolphins, his house is about 7 houses altogether. Really incredible houses, and it's really amazing to think about the real estate commission you can make on selling a couple of those things. So anyway, but tonight's legal tip, what we're going to talk about is when you represent the seller and the buyer notifies the seller that they do not intend to go through with the closing, when can the seller put the house back on the market? In South Carolina, the seller has an absolute duty to mitigate their damages. So once the buyer is clear that they are not going to follow through with the contract, whether it's because they don't qualify for financing, or they don't like the house to inspections, or they're just upset about something and they've made it very clear they're not going to go ahead with the closing, then at that point the seller may relist the house for sale. You don't have to have the release. It's always best to get the release, but the buyer cannot hold up the seller from relisting the house. Now, think about that for a minute. If the buyer could say, I'm not going to buy your property unless you do all of these extra things, and the seller says, no, I'm not going to do it, and the buyer says, well, I just won't sign the release and you just can't sell it to anybody else, even though I'm not going to buy your property, they could hold you hostage, and that's why they can't do that. So a seller has an absolute duty to mitigate their damages, relist the property once you're 100% clear and certain that the buyer is not going to buy the property. Now, if there's any questions about it, there's a dispute as to whether there is a contract or is not, I would always consult your closing attorney to make sure that there's no issues with that. But again, if you're 100% certain they're not going to, then buy the house, and absolutely you can do it. Hope to see you out at the closing table real soon, and look forward to doing another legal tip for you as well.